Hello everyone, I'm Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's video presentation is customs as a source of international law. So basically customs is a process which is being followed by a group of people or group of states, and treaties are only binding on the parties that are signed while the customs floats in the air. It's like it is there but it is also found nowhere. This means that it is not written anywhere in written format. The first thing to understand is how the rules of customary international rules are created. International Court of Justice has called it as a theory of two elements which are expressed in Article 38. That is general practice, and second one is general practice as accepted by the law. So further, Article 38 Clause 1 Subclause B of the Statute of International Court of Justice, it is considered as an authoritative statement as sources of international law, on sources of international law. The ICJ is requested to form its opinion on customary international law evidenced by general practices accepted by the law. This sets out two essential components necessary to form customary international law, which the court interpreted as state practice and opinio juris. Further, customary international law, on the other hand, derives from a general practice accepted as law. Such practice can be found in official accounts of military operations, but it is also reflected in a variety of other official documents, including military manuals, national legislation, and case law. The requirement that this practice be accepted as law is often referred to as opinio juris. This characteristic sets practices required by the law apart from practices followed as a matter of policy. And further, how to distinguish behavior undertaken because of a law from behavior undertaken because of a whole series of other reasons. So therefore, a test of customs which is divided into material fact and opinio juris. So under material fact, there are a number of points to be considered. For example, the duration, consistency, repetition, generality, and the landmark case the landmark case under which is known as the asylum case of Colombia versus Peru. Peru issued an arrest warrant against Victor Raul in respect of the crime of military rebellion, which took place on October 3rd in 1949, and in Peru 3 months after the rebellion. Further, the facts were that Victor Raul fled to the Colombian embassy in Lima, which is in Peru, and the Colombian ambassador confirmed that Victor Raul was granted diplomatic asylum in accordance with Article 2 Clause 2 to the Havana Convention on Asylum of 1928, and requested safe passage for Victor Raul to leave Peru. Subsequently, the ambassador also stated Colombia had qualified Victor Raul as a political refugee in accordance with Article 2 of the Montevideo Convention on Political Asylum of 1933, Article 18 of the Bolivarian Agreement on Extradition 1911, Articles 1 and 2 of the Havana Convention on Asylum, and thus we have unilateral right to qualify this dispute under political dispute, and this would be binding upon Peru as well. Peru denied on the claims that we have not ratified any of the such treaties mentioned. ICJ Observe, Bolivarian agreement did not entail right to unilateral qualification, and further it is a treaty on extradition and not on asylum, and it was same with the Havana Convention also. Then the Montevideo Convention on Political Asylum was also not ratified by Peru. Colombia said but it's a custom that we are following. Hence, the court, in characterizing the nature of the customary rule, held that it had to constitute the expression of a right appertaining to one state, that is for example, one state that can be Colombia, and a duty of incumbent upon another, that is Peru. However, the court felt that the asylum litigation state practices had been so uncertain and contradictory as not to amount to a constant and uniform usage regarding the unilateral qualification of the offence in question. The ICJ emphasized its view that some degree of uniformity amongst the state practices was essential before a custom could come into existence, and into Anglo-Norwegian fisheries case. Further, as I mentioned, the Anglo-Norwegian case, let's talk about that also, which is quite an important case under this, which is the Anglo-Norwegian fisheries case, which is UK versus Norway. So I'll be talking about this case in the second part of the video. So thank you.